Hello everyone and welcome to today's Mondac webinar in association with Spoor and Fisher for an insightful discussion into the Madrid system and tackling anti-counterfeiting in Africa. My name is Dan Sampaio and I'm joined by a wonderful panel today. Shamin Raghunandan is a trademark practitioner with an LLB degree from the University of KwaZulu-Natal. She is an attorney of the High Court of South Africa and a notary public. With over a decade of experience, Shamin specializes in domestic and international trade law, trademark clearance searches, filing and prosecuting trademark applications, and trademark portfolio management. She has specific expertise in counseling and assisting clients with planning and obtaining trademark protection throughout Africa. Reinard is a trademark and copyright attorney with LLB and LLM cum laude degrees. He is an attorney of the High Court of South Africa and a notary public. He has spent the past decade specializing in the enforcement of IP rights. This includes trademark infringement and prosecution, passing off unlawful competition matters, trademark oppositions, copyright opinions and litigation, company name objections and domain name disputes. He has experience in foodstuffs and cosmetic labeling complaints, as well as the enforcement of anti-counterfeiting with a focus on anti-counterfeiting in Africa. Now, before I hand over to the panel, a housekeeping item. You are able to submit questions to today's panel by typing them into the questions pane of the control panel. We will endeavour to answer as many questions as possible during our Q&A at the end of today's presentations. It's now my pleasure to hand you over to Shamin and Reinard to begin. Thank you.
Thanks, Dan, very much for that introduction. Today I'm going to talk about the Madrid system, but before I tackle that, just a little bit more background into Spoor Fisher. Spoor Fisher is a specialist intellectual property firm. We have been around since 1920. We have over 103 years of experience in intellectual property matters in Africa and also the Caribbean. We practice directly in all countries in Africa. We have offices in Gambia, Ghana, Malawi, Zambia, and Cameroon, and we really pride ourselves in having close ties with the registries and associates throughout the African continent, managing trademark issues and in terms of registration and also contentious issues throughout the entire 59 countries. Next slide, please, Dan. So basically what we're going to look at today from my side is a bird's eye view of the trademark landscape in Africa. I think it's really necessary to understand the context in which we operate before we look at the specific issues surrounding Madrid. We'll also look at the trademark registers and record keeping of the various IP offices. It will offer some context to the challenges that trademark holders face when using the Madrid system in Africa. And then we will examine the validity of securing trademark rights under the Madrid system at national level in African countries. We can move on to the next slide, please. So it's always good to sell Africa as well. So this particular map of Africa demonstrates the huge expand of Africa. It's the world's second largest continent. It has a land area enough to fit in the US, China, India, Japan, Mexico, and many European nations combined. Africa has a history of natural resources, many untapped in terms of diamond, gold, and gas, and it has a vast potential for sustainable agriculture. Also, it has the biggest free trade agreement in the world. It has a population of over 1.4 billion people and a rapidly expanding workplace with over 60% of the population under the age of 25. So technology and infrastructure improvements will definitely set up the continent for strong economic growth in the years ahead. But with that strong economic growth, it has resulted in a necessity for increased protection of intellectual property laws in the continent. Next slide. Thank you. So all of Africa was colonized by foreign powers during the scramble for Africa. Although African economies still face many compelling policy priorities, IP rights are slowly but surely rising up the African policy agenda. There has been a substantial growth in new laws and regulations in Africa pertaining to IP law. To meet their obligations under national treaties such as TRIPS, the Paris Convention, and the Madrid Protocol, several countries in Africa have passed trademark laws which give effect to their obligations under these treaties. You know, IP rights establish a secure legal framework for investment, and nearly all countries in Africa have functioning trademark systems, even though it may not be quick or effortless, but you can obtain some sort of form of trademark right. In terms of developments, which I think are important, Kenya is currently overhauling its trademark system. There's a 2022 bill which has been published and which will recognize service marks, well-known marks, and also give effect to Zambia's accession under the Madrid Protocol. In Kenya, we also see new anti-counterfeiting developments, which Reinard will cover on later in his presentation. Next slide, please. So the role of IP officers is vital in the context of securing proper trademark rights. These officers, have to work properly to ensure that there is efficient and transparent trademark searching, examination, and registration procedures, which will enhance foreign investment, build confidence, and also help stimulate growth in African markets. IP officers in Africa are not without their challenges. Some include lack of resources, funding, infrastructure, and skills are some of the issues that they face. At this stage, it is critical that IP officers modernize their systems, embark on continued training and development. Now, WIPO, the World Intellectual Property Organization, is instrumental in offering assistance to IP officers, including the utilization of the software for the administration of IP rights, including trademarks, patents, and designs by a particular African IP office. Then we can move on to the next slide. Now, this is an example of the IPAS system, which is the Intellectual Property Administration software owned by WIPO, and which is used in most African countries. So with the installation of the IPAS system, records are in the process of being digitized with the assistance of WIPO, and the registries are moving away from manual records. This in turn means that trademark searches become more meaningful, less time-consuming, and also costly. IPAS has improved access to records and trademark practice in Africa. It's particularly relevant for record keeping under the Madrid system. How it works is that incoming Madrid designations are received automatically via the system and could even be published and examined and published seamlessly. This reduces the risk of error which could occur when an African national IP office enters the data related to an international registration. So IPAS is significant for the proper record keeping of international registrations. Despite ongoing digitization efforts, it could take many years to complete the process due to large volumes and also the records being in disarray at the various registries. But this is a welcome development as it does enhance, does make trademark searches and obtaining records easier to obtain. at a national office in Africa. Next slide, please, Dan. Now, we have over 50 countries in Africa, and each country has its own nuances and concerns. So it's very important to allow sufficient lead time for filing trademarks. The route to registration includes national, regional, and international procedures. Africa is the only continent in the world that actually has two regional systems, and we'll look at that a little bit, look at that more later on. But in summary, we've got the AWAPI system, which covers 17 French-speaking countries in West Africa, and ARIPO, which offers protection for 13 countries in Southern Africa. And then obviously with the Madrid system, but it has its unique pitfalls, which we will cover soon. Next slide, please. So this is ARIPO. I'm not going to spend a lot of time on this, but just understand that ARIPO is a system that you can use, but it does have a few deficits. ARIPO is not a member to the Madrid system, but the countries which are party to the ARIPO system are members, excluding Tanzania and Uganda. The countries which are highlighted in red on the slide are Madrid member countries. There are some concerns about utilizing the system, utilizing the ARIPO system. ARIPO member countries have a common law heritage, and a treaty such as the Banjul Protocol, which governs the system, cannot be self-enacting. In other words, national legislation is required to give effect to the obligations and rights created by an international treaty. So there are some countries where we have concerns that the system is not effective because the national law does not domesticate the provisions under the Banjul Protocol, but there are the other countries, the 7 other countries where the system is effective. ARIPO is very similar to the Madrid system. You can designate countries where you want protection. You can go the national route or you can go the ARIPO route. But we just want to issue caution regarding ARIPO because it doesn't work for the reasons, in some countries, for the reasons that I've mentioned. Next slide, please. Now we have AWAPI. AWAPI is very similar to the the European Union trademark. You can call it the EU of Africa, and it is covers 17 French-speaking countries, and it's based in Cameroon. So it's a centralized system. It's not possible to designate individual countries. The AWAPI member countries have renounced all their national laws, and if you want protection in the countries which are member to AWAPI, then it is necessary to file via the AWAPI route. You cannot file national applications. AWAPI historically used to be a deposit system, but there wasn't really any significant examination. It was only in respect of formalities, but that changed in January 2022, and the legislation basically gives effect to a lot more meatier issues surrounding trademarks. Very importantly, the amendments into 2022 made provisions for international registrations, which were incorporated in the Bangui Accord, which governs the AWAPI system, and we'll have a look at that and later on. So we can just move on to the next slide, please. So now we're going into the Madrid system. So this is just the legal framework for the system. As many know, that the system is governed by the Madrid Agreement and the protocol, and it's used for the purpose of trademark owners securing protection in several countries by single registration in their national trademarks office, followed by a deposit with the international office at WIPO in Geneva, and you designate member states where protection is sought. Now, the Madrid Agreement is the legacy, and the Madrid Protocol is the way forward, with the agreement not being operational since 2016. So there were many improvements with the protocol. For example, the agreement only allowed for the accession of individual states, whereas the protocol opened up the opportunity for accession by intergovernmental organizations in addition to countries. Another difference is that the agreement only allowed for a period of 12 months for a local office to issue a refusal, whereas the protocol extended that to 18 months. We can move on to the next slide. So this slide covers the Madrid System process in a nutshell, and I'm not going to look into too much detail, but as some will know, that any trademark owner who is domiciled a national of or has a business in a member country may use the system. A trademark owner files a basic or a domestic application at the registry in their territory, known as the Office of Origin. The international application designates specific territories, and then it's filed with WIPO through the Office of Origin, which is responsible for ensuring that the international application meets all the requirements of the basic application or registration. WIPO will only examine the application for formalities only. It then records and publishes the mark and notifies the designated contracting parties or the local offices of each designation. And then the local office of the designated contracting party will conduct a substantive examination similar to national applications in accordance with national laws, which may include publishing the mark for opposition purposes. So the local office has 12 months to complete the examination, or 18 months, and if refused, then the trademark holder would usually have to instruct local counsel to handle that refusal and deal with issues under national law. Next slide, please. So there are several advantages of the Madrid system, but the point that I want to get across is that most importantly, it establishes a global system to request, obtain, and manage trademark protection. It facilitates the protection of trademarks in export markets through a simple, efficient, and cost-effective procedure, and also to managing rights in terms of renewals and changes. But it is still a procedural treaty providing an alternative procedure to secure a national trademark right. We can move on to the next slide. There are also disadvantages of the Madrid system. Now, every trademark owner has to decide whether the Madrid system works for them or it doesn't work for them, depending on the territory concerned. Importantly, the Madrid system or the Madrid Protocol does not contain substantive provisions for or grounds for refusal. It does not replace national laws and processes. It's not a parallel procedure for securing a trademark right. The procedure for obtaining trademark rights and their scope are defined by national law or the regional applicable law. So the protocol is also a closed treaty. It can only be used by those who have a connection with one of its contracting parties. So very important, does not replace local national laws, and the protocol does not deal with substantive refusal issues. We can move on to the next slide. So there are currently 24 African countries which are member to the Madrid System or the Madrid Protocol. You know, the system works effectively in a number of other jurisdictions, but there are challenges regarding its efficiency in Africa, and that varies from country to country. Notable countries which are not Madrid member countries are Angola, Ethiopia, Nigeria, South Africa, Tanzania, and Uganda. The Madrid Protocol has been on ice in South Africa for a very long time, but we've had some rumblings that within the next year or two, it could become incorporated into South Africa's national law. But yeah, we're very interested to see how that develops. We can move on to the next slide, please. So to determine the validity of the Madrid system within the African context, there are three key criteria that we look at. So for an international registration to be valid and effective, you know, it depends on whether the territory concerned has a civil law system or a common law system. Now, civil law countries, international treaties are generally accepted as binding on a national territory without domestic legislation and may even prevail over national laws. So the Madrid Protocol is an international agreement. In a common law country, for the principle of an international law to have effect on domestic law, it must be expressly and specifically transformed or enacted in domestic law. So that's number one, is looking at whether it's recognized by domestic legislation. Secondly, the national registries must process and examine international registrations in accordance with their domestic legislation and within the 12 or 18-month period in respect of which they have to issue a provisional refusal. But there are challenges there, which we will look at in detail shortly. So there are local considerations which impact the validity and effectiveness, and which could put a trademark holder's rights at risk. So it's really important to take into these issues into account when, you know, building any filing strategy for Africa. So we can move on to the next slide. So in this particular slide, what we have here is a list of countries on the African continent where the local laws do not make any provision for the Madrid Protocol. So we regard these specific countries as no-go zones in terms of trying to secure rights under the international registration system. So I'm going to first touch on Eswatini, Lesotho, Sierra Leone, and Zambia. These are what we consider common law countries, and there is just no reference to the Madrid system in the present national laws of any of these countries. So an international registration designating these countries, in our view, cannot be lawfully processed by the registrar of trademarks, nor can it be recognized or enforced in these countries. The only reliable protection is by means of the national trademark registration. You know, even though they can be designated under the Madrid, you know, when filing an international registration or a subsequent designation, we do not recommend that it is done because, like we said, examination and validity is determined at national level, and there's no reference to it. In addition, there's no procedures or mechanisms or guidelines that have been put at national level to ensure that the IP office is equipped to deal with and process IRs on a national level. You know, there's lots of peculiarities with the Madrid system, and mechanisms such as transformation or even replacement. And if there are no guidelines for the registries, they have very little understanding of how to deal with these issues. And Zambia is also a bit of a anomaly, because Zambia does not make any provision. Well, the current legislation as it stands doesn't make any provision for service marks, yet there are thousands of international registrations that cover service marks in Zambia, and clearly this is, has no effect. Another issue with Zambia is that the renewal term is 14 years, but the Madrid Protocol renewal term is 10 years. So as you can tell, there's lots of inconsistencies. Now, what I've done here on the right-hand side is that I've extracted statistics from WIPO's IP statistics portal, forgive me, and I extracted them from the year that a particular territory acceded to the Madrid Protocol. And you can see the stats speak for themselves. There have been, since Eswatini joined, for example, there have been close to 20,000 designations, and there have been no refusals by the Eswatini registry relating to international registries. In our experience, the Eswatini registry does not deal with them at all. They are completely overlooked. For Lesotho, only 2, Sierra Leone 0, Zambia just a handful. So the lack of examination of international registrations in these countries as well is a clear indication that the registries are not really processing them. Now, Awapi is a little bit different. Awapi would not be regarded as a civil law country, and the situation is a little bit different. So Awapi joined the system in 2015. However, it did not amend its laws under the Bangui Accord. Instead, it joined by a simple resolution of its administrative body. But as of 1 January 2022, the Accord now makes specific mention of international registrations. However, amendments to the Accord require formal ratification or consent by each member state, something that has not happened. So while the law does offer clarity and guidance on international registrations, this is still very, very much a gray area, as the member states to Awapi have not consented to the amendment. Furthermore, the relevant procedures of the registry are also being finalized, and the staff are being trained in the processing of international trademark registrations. Awapi does have a history of examining international registrations designated under the protocol, but it's a tiny fraction compared to the number of designations since 2015. So we would not recommend Awapi designating Awapi under the international registration system, and we would recommend filing directly with Awapi until such time that all national procedure, all Awapi procedures have been dealt with. We can move on to the next slide, please. So this table covers countries which we've highlighted in amber, where it's also a little bit uncertain, and it depends on the circumstances. Now, these specific countries that we've listed do actually have national legislation which recognize the Madrid system, but the registrations or the designations under the Madrid system are questionable and vulnerable to challenge. So these specific countries do not have active examination of international registrations designating their territories, and they also do not advertise regularly in journals for opposition purpose purposes as is required by national law. And there's also complications with issuing statements of grants, protection, which is comparable to your registration certificate. So these marks, in our view, well, the international registrations designating these specific countries could be challenged by a third party on the basis that they were wrongly accepted. So they're mostly, you could say that they're predominantly going through to registration via the process of tacit acceptance. Examination is too sporadic in respect of these international registrations, and these countries do examine at a national level, and it is a regular examination. So the problems with regard to international registrations designating these specific orange countries or amber countries is that there's a lack of training of the registry or IP officials, skilled staff, resources, infrastructure, and technology at the registries. Significant backlogs also mean that the 12 or 18-month period is difficult to adhere to. So these local challenges make it extremely difficult to ascertain if a trademark was ever granted and if it is enforceable under national law. And so we would be very, cautious about relying on these designations to enforce IP rights in Africa. We've also encountered problems with the IPAS systems at the registries where the official maybe does not have an understanding of how the renewal date works under an international registration, recording the renewal date as the date of designation as opposed to the date of the international registration. And as you may know, you can also limit the classes in a designation, and in some cases we've seen that the registry does not record the limitation and the mark is entered in respect of all classes covered under the original international registration. So these are a number of problems that are happening in these countries which have domestic legislation, but there are problems with examination due to local issues. Also, when we do encounter these problems, we have a direct line of communication with the Madrid legal department and WIPO, and we alert them to these issues. They in turn arrange proper training with the IP registries on the Madrid processes and forms in particular, and we also alert the officials of the local registries of these particular challenges or misunderstandings of the system. Another issue is that WIPO is very active with training officials on the Madrid system forms and processes, but what we see happen, what happens is that there's only one or two skilled staff at the registry who has a specific understanding of the Madrid system and how to process it at local level, and they will go to WIPO for training for months on end, and there's no backup to handle specific the issues at that local registry, which then also causes a further delay. So Namibia is one of those countries that has recently started examining from 2018. That's when the new law came into effect that recognized international registrations. Prior to that, nothing was really happening. So there have been a significant number of refusals or substantive examination issued in Namibia, but that's not, that's only recent. So there's a lot of activity. So it depends, you really have to consider your right, when it was designated, and to determine, whether it is a secure right. Yeah, so I think I've covered a lot on that, on this issue. We can move on to the next slide, please. So this slide covers countries where we have a high degree of comfort in using or under the Madrid system. So these countries basically have, historically, they have long established practices of recognizing and processing Madrid registrations. And they also have domestic legislation which gives effect, so that those two issues hand in hand make these countries countries which are effective under the system. And the stats here also is a good indication that there is active processing of Madrid international registrations, where there is a considerable number of refusals. Cape Verde, just note that it recently acceded to the protocol, so we haven't encountered any refusals as yet. The same with Mauritius. Botswana, I'm going to look at shortly, but we can move on to the next slide, Dan, please. So this is a nice heat map of just the countries where international registrations are applicable and not applicable. We can move on to the next slide. So I just wanted to show you an example of what happens at national level relating to IRs. Now, Botswana joined the protocol in 2006. Domestic legislation came into effect in 2012, incorporating the Madrid Protocol. And you can see the stats speak for themselves, which have been obtained from WIPO's websites. Total designations from 2017 to 2022, and then for many years, nothing. There's no record of a refusal being issued, and then activity began at the end of 2015. So although we've given Botswana the green light just historically, the international registrations designating Botswana prior to examination could be vulnerable to challenge. This is just an example of an international registration as recorded on the International Web Register on Madrid Monitor. So you'll see here that on the International Register, it says that the refusal period has expired and the mark has proceeded under the Rule 5. This refers to tacit acceptance where no refusal has been raised. And then here on below that, you will see that little snip shows what the details of that mark is on the National Register. It says Madrid Substantive Examination, which means that it hasn't been examined in Botswana. So just bear in mind that with Botswana, it's yes and no depending on when it was designated under the system. And then I've given some examples of examinations issued by the local office, which you may find, sorry Dan, next slide please, which you may find useful. I mean, they're issuing them properly right now. There've been some challenges or irregularities, but we have seen a general improvement into examination by the Botswana office. They're very clear on the timelines and the issues relating to the refusal or substantive examination. Next slide, Dan. And the Botswana is also issuing an interim status, basically declaring that the mark has been accepted and it will be arranged for advertisement as well as a statement of grant, which is obviously very reassuring to any trademark holder. If we can just move on to the next slide, please. This is an example of a late examination, which was issued by the local office, which WIPO will disregard as an examination and will not record it on the International Register. but we will advise our clients, in spite of any late examination where it's beyond the 12-month or 18-month period, that respond, comply, make sure that the mark proceeds in line with national levels, in line with national requirements and processes. So that mark was, this specific mark, there was late examination, it wasn't recorded, but it was then accepted and then arranged for advertisement in the local journal. Next slide. I see that I'm, it's becoming a bit too long, but the next few slides basically just demonstrate local publications in Mozambique. Now, Mozambique is one of those countries that has joined the protocol in 1998, and the 2006 and 2016 acts made provision for Madrid registrations. Just be mindful of Mozambique, that there is a non-extendable deadline of 1 month, and documents have to be submitted in Portuguese, and extensions, like I said, extensions cannot be obtained. So very importantly, when dealing with an examination or refusal, just be mindful of the deadlines. And some countries have shorter deadlines than others. Most countries in Africa, you can secure extensions, so the deadline is not, you can work around it, but Mozambique and Zimbabwe, also Zimbabwe, where you have a maximum of 3 months. And then we can move on to the next slide, and that's just an example of publication for opposition purposes in Mozambique. And next slide, please. I'm not going to go into this in much detail, but just understand that Mozambique does not make any provision for the cancellation of a trademark on the basis of non-use. What it does require for national and international registrations is the filing of a declaration of intent to use, and that must be filed via a local agent directly with the Mozambique IP office. In 2016, the IP office issued guidelines as to how to calculate the filing dates for DIUs for international registrations. So just keep that in mind. Next slide, please. So this is just an example of a state interim statements issued by the Namibian Trademarks Office. The unusual thing about Namibia is that it does examine, and it's now currently publishing IRs for opposition purposes. But there's an additional step. The Namibian local office will require the trademark holder to appoint a local attorney to arrange for advertisement. So even if the mark's accepted, there are no issues. For advertisement to take place at national level, a local agent has to be appointed. Next slide, please. I'm not really going to discuss this, Dan. We can move on to the next slide. Yeah, just know that Mauritius and Cape Verde joined the system just recently, and it's yet to be seen how they will process international registrations. Next slide. So this is just, we've dealt with it significantly, IRs designating African countries, but there's still a number of applications leaving Africa, followed by African applicants, but you can see the stats indicate that the system is still underutilized in Africa. Next slide, please. So that's the overview of the Madrid system in a nutshell, and just some key takeaways for you to consider. Importantly, many countries are first to file jurisdictions where a registered right is so important to take action against an infringer. So if you do not have a secure and enforceable and valid right, it doesn't really build any confidence. So we have our doubts, and we've explained these doubts about the Madrid system. So it's still a recommendation to file national applications in a number of countries, which refers to file jurisdictions. Also, you know, where the local legislation has not been enacted to give rise to the Madrid Protocol under national law, you know, relying on constitutional arguments about the validity of an international treaty is also not the best way to deal with things. We would recommend that before an international registration is designated for Africa, that the local laws be considered, the timelines be considered, and it's best to deal with a local attorney to secure advice on the issue. And also, doing searches in Africa does include doing a search of WIPO's records, because it doesn't necessarily mean that international registration designating an African country is on the record. So we would always recommend to do a WIPO search as well. And that's it from me. Thanks so much.
Thanks, Shamin and Dan. As Dan mentioned, I am a partner at Spoor Fisher, who specializes in the enforcement of IP, and specifically a focus in combating anti-counterfeiting in Africa. And when one is talking about counterfeit goods in Africa, it is always a good departure point to first quickly explore exactly what counterfeit goods are before addressing the enforcement thereof. Next slide, Dan. Sorry, next slide. Sorry. So in layman's terms, counterfeit goods are generally referred to as pirate products or knockoffs or fake products. The older generation generally associated counterfeit goods to pirate DVDs or CDs, whereas the younger generation generally associated counterfeit goods as fake clothing or accessories. However, what people generally don't realize is that counterfeit goods are a lot broader than that. Now, any product that has branding on it can be and will be counterfeited. For example, on a daily basis, I will encounter counterfeit goods such as brake pads, bearings, shoe polish, spices, and even pharmaceutical products. So literally any product that will have branding, you will find that that product can and will be counterfeited. Next slide, Dan. So what is the legal what legal qualifies as counterfeit goods? So basically, where a product is manufactured and an IP is attached or applied to that product without the authorization of the IP holder, that product will constitute a counterfeit product. And when I refer to IP, and specifically in the African context, that will be limited to trademarks and copyright. Now, I don't want you to get confused between counterfeit goods and parallel goods, where parallel goods are products that are manufactured by the brand holder or the IP holder, and the goods are the trademarks or IP is applied by the brand holder, and that goods are specifically designated for a specific region, where those goods are diverted to a region not authorized by the owner. Those goods will be parallel imported products and not counterfeit goods. Next slide, Dan. Now that we have covered what counterfeit goods are, let's look at what enforcement options a brand owner has in order to combat counterfeit goods in Africa. And when one is looking at enforcement, one should first consider, and specifically when it comes to Africa, what countries have sufficient legislation in place to combat counterfeiting. Now, when it comes to Africa, there are only real two countries that have so generous anti-counterfeiting legislation, and that's just a fancy word for legislation that is specifically drafted to combat counterfeit goods. And those countries are South Africa and Kenya. Next slide, please. So when one looks at South Africa, they enacted the Counterfeit Goods Act in 1997. It is a very efficient piece of legislation to combat counterfeit goods. It authorizes the police, customs, and Department of Trade and Industry to do marketplace enforcement and also enforcement at the border. It also makes specific provision for customs recordals, which is very well run by the customs authorities, and we have multiple success cases in South Africa for marketplace and border patrol enforcement. Next slide, Dan. Looking at Kenya, similar to South Africa, Kenya also have a specific legislation called the Anti-Counterfeiting Goods Act. It was enacted in 2008. Unlike South Africa, the Act makes specific provision for an authority to be created. It's called the Anti-Counterfeiting Authority, who is mandated to combat counterfeit goods in Kenya. Now, the ACA are very efficient in marketplace enforcement. We have a lot of success with the ACA and we work very closely with them. But until recently, they don't really focus on the borders. However, in light of recent developments and amendments to the regulations to the Act, they have started with customs recordals. However, I'll touch on those a bit later in my presentation. Next slide, Dan. For the remaining of the African countries, banner holders will generally be limited to specific IP laws, which will generally include Trademarks Act, the Industrial Property Act, Merchandise Marks Act, or penal codes, in order to enforce against counterfeit goods in Africa. So from our experience, there are certain countries that's more suited to enforce against counterfeit goods than others, and we generally would recommend countries such as Tanzania, where the Fair Competition Commission is very well situated and they have procedures through which you can combat counterfeit goods. Then you have Zambia, who has the Bureau of Standards and the police. They are very helpful in those, and they're very good in getting the goods destroyed. In some jurisdictions in Africa, it takes years for the goods to be destroyed. In other jurisdictions, they're quite quick, and Tanzania and Zambia are some of the more quicker jurisdictions. Then you have Ghana, Angola, and Uganda, where the police and the customs are very good. I'm not going to go into more detail on that, and time is a bit running out. So, but I'm just wanted to highlight that there are countries that have proper legislation through which one can act, and it is very efficient in those instances. Next slide, Dan. So with the Madrid theme today, I thought I would touch on what Madrid can offer brand holders in respect of enforcing counterfeit goods in Africa. And this map just shows, and I think the slide on the left-hand side, Shamin already made reference to, is all the Madrid countries. And the slide on the right is an illustration of, from our experience, which countries counterfeit operations are reasonably possible. So this is not a really exhaustive list. Even though the country is not highlighted, they do have IP rights, and one can technically enforce against counterfeit goods. It is generally very difficult to enforce in those jurisdictions, and it's financially not generally feasible to try to operate in those jurisdictions. I also just want to highlight from this map, you'll see that WAPI is highlighted. I'll go into a little bit of detail on WAPI, and that's the French-speaking countries to which Shamin already referred. Next slide, Dan. So just to go into a little bit more detail in the countries that have accepted IRs. And again, first up is Kenya. As I already mentioned, Kenya is one of the African jurisdictions which make adequate protection against counterfeit goods. Since Kenya has adopted the Madrid Protocol, the IP holder has the option to rely on the international registration in order to file a complaint with the ACA. And also, and as I mentioned, they are implementing customs recordals, and one can also then rely on your IR for those customs recordals. Then talking about WAPI, even though we generally do not recommend following the WAPI route for IRs, if you have an IR registration, we have in the past been able to rely on those registrations in some of the countries, but for that you need to contact the WAPI office, and for that you need also to get a certificate of non-radiating registration and also a certificate of non-forfeiture. That is generally sometimes difficult to get, so even though it is technically possible, there is some challenges involved in getting those certificates. Then quickly just looking at Botswana, Namibia, and Ghana. As mentioned by Shamin, some of them featured on the orange list of her slides. These countries have accepted the Madrid Protocol, and one can designate these countries. However, they are experiencing some difficulties with the trademark registries where the system has some problems, and most designations have not been examined now or advertised. Now, since there's a backlog on those processes, you don't generally find that the IR is getting through to registration, and therefore you might have difficulty in getting enforcement based on counterfeit goods. I also just mentioned at the bottom Zambia, as Shamin mentioned, they are at this point in time relying on a very old Trademarks Act, but they are very far down the process of amending their new Trademarks Act, and word on the street is one of the main amendments will be to enact Madrid. So hopefully in the near future, owners of the IRs can also rely on their IR in Zambia to enforce their rights. So as can see, we've seen from this that owners on international registrations have some benefit through their IRs to combat counterfeit goods in Africa. Next slide, Dan. So just quickly touching on what the most important developments in Africa is when it comes to counterfeiting. And the main one, as I quickly mentioned earlier, is the customs record, the ACA recordals in Kenya. Now, the ACA has recently amended the regulations of the Anti-Counterfeiting Act to make provision for customs recordals. What is unique about this customs recordals is that the Act makes it mandatory to have a recorder in place in order to import goods into Kenya. So basically, unless you have a customs recorder with the ACA, you will not be able to import products into Kenya. There have been numerous deadlines set by the ACA for recording these ACA recordals. However, all of them have been extended, and the last deadline has been extended, and there has been no new deadline given. So at this point in time, there's no deadline, but we'll need in the near future hear whether there's any further deadlines. Next slide, Dan. So as mentioned, so if a brand holder wish to import goods into Kenya, they will need to have a recorder, because ACA will monitor any branded goods entering the Kenyan borders, and if no application has been filed for marks, specifically the house marks featuring on the products, it will be seen as infringing products, and penalties will be issued to the importer. Next slide, Dan. As mentioned, you can rely on your national and IR registration to file a recorder. However, the Act makes actually provision for brand holders to rely on any foreign registration to apply for a recorder. So even though you don't have a national registration or an IR, if you have a registration in another jurisdiction, you can still rely on that application or that registration to apply for ACA recorder. Since the system has not yet been operational, we are uncertain how the ACA will deal with the enforcement of these foreign registrations, but at this point in time, the ACA have accepted applications in which foreign registrations were cited. Next slide, Dan. Lastly, just on the current status of the ACA recordals, the system, the portal through which applications were filed, was down since March. I think in 2 weeks ago, the portal went live again. So applications can again be filed and be processed. However, the system is very fragile, and there's a lot of loading time involved. With regards to pending applications, because of the fact that it's mandatory, the ACAs are receiving a massive amount of applications, and they're a bit short-staffed at this point in time, so the application process is a bit slow. But we are, from our side, we generally try to assist them with any applications where we can. Even though these problems that the ACA are experiencing, we would still encourage brand holders to file these customs recordals if they intend importing branded products into Kenya. Just another development, which is not on the slides, and I think I already just touched on it, is the Zambia, which is like to manage Trademarks Act, which will specifically focus on incorporating the Madrid and also service marks into Zambia. Just next slide, Dan. Just on the roadmap, I generally I generally, when I speak about counterfeiting in Africa and potential brand holders, I try to give them a roadmap as to how to enter the frame for enforcing counterfeit goods in Africa. Now, next slide, Dan. The first thing we always suggest is that the brand holder conduct a market survey. A market survey will tell the brand holder whether there's a problem in the specific market or not, and through that they'll know whether to take reactive or proactive steps in order to safeguard their rights. Next slide, Dan. If the market survey reveals that the brand holder has a counterfeit problem, the brand holder will generally need to take reactive steps in combating against counterfeit goods, and that will generally be done by either conducting a search and seizure operation, or if the quantities are generally low, we can start with a cease and desist letter campaign where we have investigators, we'll deliver the cease and desist letter together with the police, and generally we'll try to get an undertaking from the suspects selling the counterfeit products. Coupled with these search and seizures or cease and desist letters, we generally recommend that we do brand identification training simultaneously with these operations, because that would place the authorities in a position to be able to determine whether goods are counterfeit or not. And also generally we'll try to involve various clients at the same time, which will generally also then keep the cost low for the specific clients. Next slide, Dan. Sorry, and then next one after that as well. So customs recordals, like I mentioned, there are not a lot of countries in Africa that have specific customs recordals. Kenya and South Africa from our side is generally the main ones. At this point in time, however, through our relationships with various authorities in African police and customs, we have developed informal customs recordals where we will be contacted by the authorities through various channels, but we have created WhatsApp groups with the specific authorities through which they can communicate with us when they become aware of suspicious goods. For those informal customs recordals, it's very important to have brand identification training, because this will put the authorities in place to determine whether goods are counterfeit or not. Next slide, Dan. Okay. So I went through it very quickly, just new trends. Next slide, Dan. So after COVID, a new trend has become very active in Africa, and that's online sales. I don't think it's limited to Africa. People has become more comfortable doing online shopping, and the counterfeiters have seen this space, and they are more actively following online sales route. It's generally more difficult to trace them. However, we are very active in this field, and we specialize in these takedowns or these raids. So this is just one of the new trends that is sticking up his head. Next slide, Dan. And just the last point I want to touch on is land borders. Now, in the past, because we have been so active in giving training and at the ports of entry, in the sense of the harbors or the airports, the counterfeiters have noticed an increase in detentions. So they have started to try to get the products in through land borders, and they will generally try to do so by either declaring the goods as a transshipment or a goods in transit for a landlocked country, and then once the goods are either through the country in a designated country, just simply bring it back through the other border, which is not generally as manned and trained as the main ports of entry. Yeah, thanks, Dan. That's the next slide, and I'm done with my presentation. Thanks.
Thank you very much, Reinard. Thank you very much, Shamin, for your presentation today. You have so much information in such a short amount of time, and we really appreciate your efforts and your insights today. Unfortunately, we're just out of time for a Q&A session, but any questions that you did send in will be sent on to the panel, and we do encourage you to get in touch with the firm, with Reinard, with Shamin, for any questions that you do have. So I will thank you for being with us today. We really appreciate your time being with us. Shamin, Reinard, I will hand over to you to say your goodbyes as well.
Thanks so much, Dan. It's been a pleasure. So please contact us if there are any specific questions. We will be happy to assist. I'm referring to the audience.
Yes, thank you very much, guys, for listening. And yeah, if, like Shamin said, if you have any questions, please do not hesitate to contact us. Thanks.
Brilliant. Thank you very much. Thank you once again. I hope you have a lovely rest of your day. Goodbye.
Thank you. Bye-bye.